the trial court abused its discretion when it found that the motion to enforce and for contempt, which was filed by the appellant in this case, did not warrant the court's attention or intervention or the scheduling of enforcement proceedings. This case is important and should be important to this court because it represents a clear violation of my client's constitutional rights to access to justice, which is fundamental in our state's constitution. That concept is not only articulated in Chapter 1, Article 4 of the Vermont Constitution, but it was also touched on in the Zorn case. This case really implicates a litigant's right to justice. In this particular matter, the parties agreed to a very specific provision in their order, which was signed and acknowledged by the court. It is the only provision in that order which was handwritten in. It was as a matter of contract important enough to the parties to write this specific provision in. It was an essential element to a bargain for exchange. The court authorized that agreement and signed it as an order. When it is undisputed between the parties that Attorney Broadfoot's client did not comply with the order. It is not disputed. She agrees that her client did not provide this particular minor with access to the particular programs which were chosen and facilitated by the guardian indicated by the guardian ad litem in this case, which was the whole point of the guardian's presence, otherwise rendering the guardian's intervention utterly meaningless. It is also undisputed in page 12 of their brief that there is, and this is an unusual provision, as they write. It is an unusual delegation of authority to the child, and the child's preferences would be communicated to the parents, agreed to be obligated to facilitate this minor's involvement in those programs. The word program is important here. It does not say activity, it says program. Programs are very specific. It did not contain an absolute veto power, as is suggested in this case. If my client is denied the opportunity to have this matter addressed by the court, it leaves my client without an avenue to justice. It leaves the court to be able to decide, as in this case, that certain provisions of a party's contractual agreement it deems petty. It also leaves practitioners with a very specific quandary. How do we advise our clients? Do we tell them the court perhaps may perceive a very important provision that you have entered into your agreement as meaningless and petty and may not simply enforce the order, even though there is an agreement that there is non-compliance? What does a practitioner do if we cannot access justice? How do we tell our clients that we should then go to mediation and make agreements, which in this instance, the court encouraged the parties to do, and which they did. And then the court determined that this was a minor conflict and a minor provision, which the court decided that it would not entertain. I would submit to this court that this is a very severe violation of my client's ability to access justice and chills litigants' interest in resolving their own disputes with other parties, because it gives them no surety that the court will actually enforce the very things that they find important and that they find meaningful enough to place into their orders. I believe that this was a very elemental abuse of discretion, and I believe the court should return this matter back to the Superior Court to hold a hearing on this matter and hear the parties. If the court has no further questions, I will rest my argument.
All right, thank you, counsel. I don't see any hands or questions. Counsel for the appellee, please introduce yourself and your client, and you may proceed.
Thank you, Your Honor. My name is Cynthia Broadfoot. I'm here for the appellee, Mary Cotton. Appellant wants you to believe that this case is about access to justice. It's not. They want you to believe that appellant's constitutional rights have been violated. They haven't been. What this case is really about is the authority of the court to manage its docket. Rule 7 of the Vermont Rules of Civil Procedure gives the court discretion to determine whether or not a hearing or oral argument is necessary. No one is disputing that the court has that discretion, and it's within the court's rights to deny a petitioner a hearing or oral argument. Appellant argues that the court's discretion is not absolute, but appellant has not shown that in this particular case, there was any abuse of discretion. With the benefit of hindsight, perhaps judicial economy would have better been served if we had gone to a hearing at the trial court rather than being here today. But holding a hearing in the trial court would have been the easy way out, and it would have effectively gutted Rule 7. It would take away the court's authority to decide whether an oral argument or a hearing is actually necessary. In this case,
didn't the trial court actually make a specific finding though, without having a hearing, about this not being a clear violation of the parties' agreement?
I think they did, Your Honor, based on an understanding that the evidence really wasn't disputed. The evidence was that the child had been with my client during eclipse day when school ended up closing. The evidence was not disputed that the child was participating in rock climbing in Essex as opposed to South Burlington facility. The evidence was not disputed that the child was skiing at Smuggler's Notch with my client rather than Sugarbush, where the appellant was skiing. So these issues were not disputed, and what the court decided, and rightly so, pursuant to Rule 7, is that they talked about that these were minor conflicts and disputes about where the child was going to ski or rock climb, and that it didn't warrant the court's scarce resources. And that was within the court's rights under authority under Rule 7. Appellant's contention that there's a clear violation of the order and that is somehow agreed upon is disputed. My client believes that there was no violation of the order, and the court used its discretion to determine that these issues didn't necessitate a hearing because they weren't clear violations and they weren't substantial. They were minor, to use the court's words. The court went on to make suggestions to the parties to help them learn to deal with these small conflicts. They suggested mediation. Mediation is often not a one-time resource for parents to work out disputes like this. They also suggested perhaps use the guardian ad litem if he's willing. And they also put in the order, if a referral to parent coordination would help under Rule 4, they would be open to that. Appellant did not avail herself of those things. Instead, she chose to appeal. The irony of appellant arguing that this case is about access to judgment has not been lost on my client. Since the parties divorced in 2018, this has been a very litigated case. This is not our first trip to this court, and I couldn't help but notice that appellant included in the printed case a copy of her most recent motion, an emergency motion to completely suspend my client's parent-child contact. That motion received 6 hours of hearing time in the courts and has been pending for 9 months. It's under advisement now as we're here today. This is not a situation where appellant has not had access to judgment and where her rights have been violated. This is a prime example of the court needing the Rule 7 authority to be able to manage their dockets. The cases cited support that, and these were minor violations that the court appropriately decided did not need hearing time.
All right, and your time has expired, counsel. Thank you for your argument. Does the appellant have any time remaining?
Appellant has 30 seconds remaining.
All right, counsel.
In response, Your Honors, we did access the mediator twice. We did also seek the guardian ad litem's assistance, and the guardian advised that he believes that with the court's ruling, his intervention is utterly meaningless. In fact, his involvement is utterly meaningless. So that is not accurate. This is about the access to justice because this issue is capable of repetition and is, in fact, as we are speaking, repeating itself yet again this year. There is no way to resolve this matter at this point.
All right, thank you very much, both of you, for your arguments. Your time has expired, counsel, as well. We'll take the matter under advisement. Thank you.
Thank you.